Start. Yes, it is settled law by a catena of decisions that for establishing the offense of cheating, the complainant is required to show that the accused had fraudulent or dishonest intention at the time of making promise or representation. From his making failure to keep promise subsequently, such a culpable intention right at the beginning, that is, at the time when the promise was made, cannot be presumed. It is seen from the records that the exemption certificate contained necessary conditions which were required to be complied with after importation of the machine. Since the GCS could not comply with it, therefore it rightly paid the necessary duties without taking advantage of the exemption certificate. The conduct of the GCS clearly indicates that there was no fraudulent or dishonest intention of either the GCS or the appellants in their capacities as office bearers right at the time of making application for exemption. As there was absence of dishonest and fraudulent intention, the question of committing offense under section 420 of the Indian Penal Code does not arise. For the reasons aforementioned, the impugned judgment cannot be sustained. It is set aside accordingly. Appeal is allowed and the order taking cognizance against the appellant is set aside. These appeals are directed against judgment and orders dated 22/6/2005 and 19/7/2006 passed by a division bench of the Karnataka High Court, whereby and whereunder the judgment and order dated 7/2/2005 passed by a learned single judge of the said High Court, dismissing writ petition numbers 1651-1685 of 2005 filed by the respondents herein, claiming their absorption in the appellant corporation. Indisputably, the private respondents herein were the workmen of Karnataka Pulpwood Limited, within bracket the company. It was a government company. It was running at a loss. Karnataka Pulpwood Limited is a joint sector company of Karnataka Forest Development Corporation Limited and Karnataka Harihar Olive Fibers Limited. The share capital was fixed in the ratio of 51:49. The government stood as a guarantor in respect of the loans to be raised by the joint sector company from the commercial banks. A lease was granted in favor of the said company. Karnataka Pulpwood Limited, which is said to be a subsidiary of the appellant corporation, faced hostility from the local people for various reasons. A public interest litigation was also filed before this court against lease of foreign forest lands inter alia on the ground that the same was violative of the provisions of the Forest Conservation Act 1980. This court granted an order of stay regarding possession of the said leasehold property. Protracted legal battle adversely affected the commercial viability of KPL project. Great difficulty was also experienced in the matter of obtaining loans from banks for raising of maintenance of plantations. A question therefore arose as to whether the said company should be wound up by reason of a decision taken by the state of Karnataka on or about 24/10/1991. It was inter alia directed. Stop.